And the key issue in the Unocal case, and the key issue in many of these cases, has been what is it that a corporation has to do to be found liable for aiding and abetting? And you saw from the clip that we have taken the position that merely doing business with a pariah regime is not enough to establish liability, even though in the case of Unocal and the French oil company Total, the revenue from that natural gas pipeline project helped to keep the military regime in power. So you certainly could make an argument that there was a pretty strong connection between what they were doing and human rights violations generally in the country, but that's not the basis for these suits. And the Unocal case was one of the first cases in which there was debate about what the standard should be. And what the court ultimately decided was that you should look to international law, international customary law, on what the standards for aiding and abetting human rights violations should be, and that the most appropriate place to look was the jurisprudence of the ad hoc tribunal for the former Yugoslavia, which was based on international customary law from Nuremberg on. And so the standard that was accepted in Unocal was that a company had to provide knowing practical assistance or encouragement that had a substantial effect on the commission of the international human rights violation. And in that particular case, it was found that Unocal had done enough for a jury to decide whether they should be found liable. They had done enough by building the helipad that enabled the military to conduct its activities, that there was coordination between Unocal and the military, that the military was designated to provide security, or at least that there was enough evidence that a jury could decide that. As was indicated, the Unocal case was settled prior to a final decision in the case. And there was a confidential settlement, so I can't say what it was, although there was money involved, and we were very happy, extremely happy, very, very happy. Part of that money was a fund for others in the pipeline region, and one of the things that I think is important to note is that this was not a class action, but we were able to work with plaintiffs who believed that they were doing the case not to get personal wealth out of it, but they were doing it for an entire community. And so they gave up, in a sense, part of what they were entitled to so that others in the community could benefit from the settlement in the case. Unfortunately, because of the confidentiality, it restricts a little bit about what I can say about that, and it was a difficult decision because we gave up the opportunity to have the courts set this very good standard, because we like the standard, because the Court of Appeals decision wound up being vacated because of the settlement. So it was a tough choice. But in making that choice, it was clear that the settlement was very good for the clients. And since the settlement, I've been back to the Thai-Burma border, and I can say that the plaintiffs have done amazing things with the resources they got from the settlement. They've recreated conditions in their former villages. They've helped a lot of others in ways that are very gratifying to those of us that worked on the case. Now, before I go on to Wiwa versus Shell, I would have to just say that there's been a negative development in another case recently, a case called Presbyterian Church of Sudan versus Talisman Energy, Inc., which is another case that I'm involved in. That's a case that involves claims that Talisman aided and abetted genocide, crimes against humanity, and war crimes in the southern Sudan on an oil concession, where part and parcel of the way that the concession worked was that villagers would be cleared from areas for exploration and production, and they'd be cleared by attacks by helicopter gunships, Antonov bombers, and by the military coming through their villages and killing and torturing people. That case was, the Court of Appeals in that case only last month affirmed a summary judgment against the plaintiffs. And it did so based on a finding that the plaintiffs had to show not just knowledge of the human rights violations in question, they had to show that it was the corporation's purpose that the human rights violations occur. So the way that the Court of Appeals in New York has now looked at this under the Alien Tort Statute, which is the basis for all these cases, is that under international law, their version of the Rome Treaty, actually, is that you have to have a kind of specific intent. The company has to desire, it seems, that the human rights violations take place. There's some debate about exactly what it means, but it's obvious, it's at the other end of the spectrum in terms of holding corporations accountable. And if it stands, it's going to be very difficult to bring many cases, because it's going to be very difficult to show that corporations intended that wanted the human rights violations to occur. Generally speaking, what the evidence shows is that they didn't care. That basically they wanted to make money, and if human rights violations occurred, okay, that's the cost of doing business. Someone else bears the cost, but that's what it is. So we're faced with a very difficult ruling there, and it's not clear where it goes from there. We're going to be fighting that ruling in other courts around the United States in other cases, and we'll be going up to the United States Supreme Court to try to get the ruling overturned. Let me turn to WeWa versus Shell quickly, and I think as many of you may know, in the WeWa versus Shell case, it arises out of human rights violations that were occurring in Agoni between 1993 and 1995. In November 1995 is when Ken Saro-Wiwa and the other members of the Agoni Nine were executed by the military government. And the case, again, alleged that Shell, through its subsidiary in Nigeria, committed acts that aided and abetted the military in the human rights violations that were occurring in Agoni and in the execution itself. And again, there was no other realistic forum to bring the case, which is why it was brought in New York under the Alien Tort Statute. And we litigated the case for 13 years, from 1996 till June of this year when we settled the case. We had to overcome Shell's objections to jurisdiction, that they should not, as UK and Dutch companies, they should not be sued in New York, even though they did business there. We dealt with corporate structure issues. In almost all of these cases, the parent companies are in the United States or somewhere else where they can be, or doing business in the United States and can be sued. And the argument is that the entities that are really involved in the case are these subsidiaries that are in Burma or may exist on the shelf somewhere in the Caribbean in a lawyer's office, and that therefore it should prevent us from being able to sue them. And there's a basic conflict between corporate law that provides for limited liability for corporations and human rights law that provides for accountability for human rights violations. And that's a tension that's existed in all of these cases that is yet to be finally resolved, except that we have not yet been stymied by the corporate structure arguments that have been made. So we settled the case. This one was a public settlement for $15.5 million, of which $5 million went to the Kesey Trust, which is a trust for the benefit of people other than the plaintiffs in the Agoni. And it was very difficult to settle the case, and maybe we'll have a chance to talk about that some more, because there was a desire to have vindication before a jury in the United States about these claims. But I think ultimately the decision to settle was that, in a sense, we had made our point. We had exposed what Shell had done over 13 years of litigation. We had put the spotlight on Shell. We had made Shell face its accusers. We had given some voice to people that had a hard time finding a voice against Shell on these issues.